Hi, I'm Ken Fossen. Our topic today is one that, if it surfaces, will totally consume your time for the next several days. The topic: teachers having sexual relationships with students. Let's start by looking at the criminal charges a teacher may face if he or she engages in a sexual relationship with a student. There are two criminal statutes that may come into play. One is sexual assault in the first degree. The other is sexual assault of a child in the first degree. Sexual assault in the first degree is committed when any person subjects another person to sexual penetration, A, without the consent of the victim. That's what we immediately think of when we hear the words first degree sexual assault. But sexual relations between a teacher and a student are usually consensual. So we need to look at subsection C, which provides that the act will be considered first degree sexual assault when the actor, the teacher, is 19 years of age or older, and the victim, the student, is at least 12 but less than 16 years of age. Rather than read through the statutes, let me summarize them quickly. As we just mentioned, sexual assault in the first degree applies when the adult is 19 years of age or older, and the minor is at least 12 years old but less than 16. In other words, ages 12 through 15. The offense is categorized as a Class II felony and is punishable with a sentence of 1 to 50 years imprisonment. Sexual assault of a child in the first degree has two provisions that are age-related. One provision provides for an adult 19 years old or older, while the minor is under 12 years old. A second provision provides for an adult 25 years old or older, and the minor is at least 12 years old but less than 16. So, looking at these two offenses, if a first-year teacher, age 22, had a sexual relationship with a 15-year-old student, he or she could be charged with first-degree sexual assault, but not with first-degree sexual assault of a child. On the other hand, if the same 15-year-old student had a sexual relationship with another teacher, age 25, the 25-year-old teacher could be charged under either of the statutes. The only difference between the two charges would be the sentence. For the sexual assault, the sentence would be 1 to 50 years. For the sexual assault of a child, it would be 20 years to life. Okay, let's move away from a 15-year-old student and assume the student is 17 years old instead. Now you will note that neither statute applies to either the 22-year-old teacher or the 25-year-old teacher because the student is not under the age of 16. Does this mean the teacher is home free? No. Although the teacher may not be sent to prison, he or she will in all likelihood find that his or her teaching contract will be canceled by the district, and further that his or her teaching certificate will be revoked by the State Board of Education upon the recommendation of the Professional Practices Commission. Here are some relevant case summaries from the Professional Practices Commission website that give insight into what the teacher might expect. Case number 87-7, the respondent admitted to having sexual intercourse with a 17-year-old female student during the 97-98 school year. The PPC recommended permanent revocation. The State Board concurred. Case number 00-12, the respondent had sexual relations with a 16-year-old female student. The PPC recommended permanent revocation. The State Board concurred. Apparently, one teacher thought that waiting until immediately after the student graduated from high school would provide a safe harbor for him. He was mistaken. Case number 0507, the respondent used his position at the school to develop a personal relationship with a female student that resulted in the respondent having sexual intercourse with the student the day after the student graduated from high school. The PPC focused on the origins of the relationship rather than the date of the event and recommended a 5-year revocation. The State Board concurred. Some states and even individual school districts put specific timelines on how long the teacher-student relationship lasts following graduation. I've seen timelines ranging from 90 days to 1 year. During this period of time, the teacher is expected to maintain an appropriate professional relationship with his or her former students or face disciplinary action. Well, as if that's not enough for the teacher to think about, there's still the issue of civil litigation. The teacher may think that the student would never sue him or her, but remember, the student is a minor. so the action will likely be brought by the parents on behalf of the student. The parents may not be as enamored by the teacher as the student was. Litigation is time-consuming and expensive, so if the teacher is in prison, there are likely no personal assets worth pursuing. As a result, the parents and their attorney will likely try to find deeper pockets to sue, and that would be the school district. So let's turn our attention now to the school district's potential for liability for the acts of its teachers. If the parents decide to sue the district, the most commonly used avenues for such claims are the following: the Political Subdivisions Tort Claims Act, which is a state statute waiving sovereign immunity for certain unintentional torts; Title IX, which is a federal statute prohibiting discrimination in educational programs or activities based on sex; and 42 U.S.C. 1983, which is a federal statute providing a cause of action for the violation of a person's constitutional or civil rights. As we look at these three statutes, there's one distinction that I'd like to bring to your attention. Under the Political Subdivisions Tort Claims Act, you will recall from video number 4 that the negligent act of a teacher may be imputed to the district by way of the doctrine of respondeat superior. Under Title IX and U.S.C. 1983, the acts of the teacher are not imputed to the school. Any liability under these two federal statutes depends on what the district itself did or failed to do. So first, the Tort Claims Act. Although the act permits citizens to sue political subdivisions, including school districts, for certain unintentional acts, Section 13.910 specifically provides that the Political Subdivisions Tort Claims Act shall not apply to any claims arising out of an assault. Since the teacher was charged with sexual assault, and assaults are specifically excluded from the Tort Claims Act, any suit filed by the parents under the Tort Claims Act will likely be summarily dismissed by the court. So let's move on to a potential claim under Title IX. In 1998, the U.S. Supreme Court in the Gebser case held that damages may not be recovered under Title IX unless an official of the school district who at a minimum has authority to institute corrective measures on the district's behalf has actual knowledge of and is deliberately indifferent to the teacher's misconduct. That standard places a really difficult burden of proof on the plaintiffs. The following year, the Eighth Circuit, applying the Supreme Court's Gebser standard requiring actual knowledge and deliberate indifference, dismissed a Title IX sexual harassment case against the Omaha Public Schools. The case was brought by a former student who had had a sexual relationship with one of her teachers. Finally, let's look at 42 U.S.C. Section 1983. In PH versus Kansas City School District, the Eighth Circuit stated the following: the Due Process Clause of the 14th Amendment protects the liberty interest of a child in public schools from sexual abuse. A school district can be liable for civil rights violations under Section 1983, either 1, for failing to receive, investigate, and act upon complaints of sexual abuse, or 2, for failing to train its employees to prevent or terminate sexual abuse. The court then proceeded to discuss in more detail each of these potential causes. When the court discussed the standard for failing to receive, investigate, or act, it again required the plaintiffs to prove the school had noticed but acted with deliberate indifference. Similarly, with regard to failing to train its employees, the court required the plaintiffs to prove the school had noticed but acted with deliberate indifference. Although failure to train does not in and of itself create liability, it can provide the plaintiffs with the evidence they need to support their claim of deliberate indifference. So, in light of what we've discussed, what are our takeaways with regard to Title IX and Section 1983? Put simply, take sexual abuse seriously. If you have a school culture that cares about the rights of students and acts expeditiously when violations of those rights occur, then it will be very difficult, if not impossible, for the plaintiffs and their attorneys to bring a successful suit under Title IX or Section 1983. On the other hand, if you have a school culture of deliberate indifference that believes that sexual abuse is not a big deal, that boys will be boys, that this too shall pass away, so don't worry about it, then you may have opened the doors wide and invited the plaintiffs and their attorneys into the courtroom to proceed with their claims against the district. I hope this was beneficial. Thanks to the attorneys at Perry Law Firm for assisting in making these presentations possible. And of course, a special thanks to you for watching. See you next week.